Hey, it's Terry Gorry, and this is the Irish Law and Small Business podcast. Michael O'Sullivan won his unfair dismissal case last week, or the decision was announced last week from the WRC. However, he was awarded €250 by way of compensation. Let's talk about that. Michael O'Sullivan was a recruitment consultant. He worked for a firm owned by the former presidential election candidate Peter Casey. O'Sullivan's performance in the job wasn't up to scratch, and he was put on a performance improvement plan. And I think he was then put on a second performance improvement plan. And a meeting arose out of the second performance improvement plan. It was a meeting on around about the 18th of March 2021. O'Sullivan claimed that he was dismissed on the spot during this meeting. However, the employer denied this. It turns out that 5 days later, on the 23rd of March 2021, O'Sullivan wrote an email to a colleague as follows: "What you have done is legal grounds for you to be fired, and I have a case for defamation of character / slander against you. I expect an apology from you." O'Sullivan also told the colleague that he'd spoken to a solicitor about the issue. The colleague was extremely upset by this letter and reported it to the employer. And I think this particular colleague subsequently resigned. However, the company chairman, when he received the complaint from the colleague as to O'Sullivan's email, and given O'Sullivan's difficulty in meeting the performance standards in the job, given the fact that he was on his second PIP, the company chairman wrote to O'Sullivan and said, "You now seem determined to disrupt the Claddagh business by making accusations against employees. It goes without saying that I cannot have a Claddagh employee threatening to sue another employee," and terminated O'Sullivan's employment immediately. So this was the basis then on which Michael O'Sullivan brought the claim to the Workplace Relations Commission, claiming unfair dismissal. The adjudicator in his decision determined that O'Sullivan had not been fired on the spot as claimed by O'Sullivan at the appraisal meeting of the 18th of March. But O'Sullivan was given a warning as to his performance, and he was advised and told basically that his performance wasn't up to scratch, that it needed to improve, and it was in the way of an ultimatum to O'Sullivan. O'Sullivan then sent the email to his colleague 5 days later on the 23rd of March, and the adjudicator found that this email was the reason for the dismissal. The WRC found that this email was unacceptably threatening, and O'Sullivan had engaged in deplorable conduct, had lied to his colleague about getting legal advice, and made an outrageous and unfounded threat against a female co-worker. O'Sullivan was found to have been unfairly dismissed because the employer had terminated without even the slightest nod in the direction of a fair process, and this was an unfair dismissal. However, O'Sullivan's conduct was the primary reason why he only awarded €250 for the unfair dismissal. The adjudicator would have the discretion or the power to award up to 2 years' wages, 2 years' salary for unfair dismissal. In this case, O'Sullivan was awarded €250. The adjudicator, Mr. Brady, said, "I regard the specific conduct of the complainant as being such that it is at the extreme end of the spectrum of gravity, and his contribution to the termination of his employment is at the highest level imaginable." So there you go. The adjudicator found that essentially the employee, whilst he was unfairly dismissed by reason of the lack of fair process and natural justice and so forth, contributed so much and to such an extent to his own downfall, as it were, to his own dismissal, that the award was only €250. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.